The kitchen sink is spraying water everywhere, and your landlord is suddenly dodging your calls. You're wondering if you can legally just refuse to pay rent until they show up. The short answer is yes, but if you do it wrong, you'll end up evicted and living out of your car. The law gives you powerful weapons to force a stubborn landlord's hand, but you've to know exactly how to wield them. Today, we're breaking down the concept of landlord-tenant obligations, starting from the ground up. When you rent a place to live, you aren't just buying a space to sleep. You're entering a legally binding contract, and in the legal world, every lease carries something called the implied warranty of habitability. That's a legal promise the landlord makes to you, even if they never actually said it out loud, that the property is safe, clean, and fit for a human being to live in. If a problem threatens your health or safety, the landlord is legally required to fix it. This isn't about your broken dishwasher or a scratch on the wall. The law doesn't care about cosmetic annoyances. The law cares about the bare minimum standards for human survival. We're talking about a collapsing roof, a busted furnace in the dead of winter, raw sewage backing up into the shower, or black mold spreading through the ventilation system. Those are the types of severe failures that breach the warranty at habitability. When a landlord ignores those massive issues, they're breaking their end of the deal, which means you've legal options to force the issue. But you can't just wake up mad and decide to stop paying rent. You've to follow a very strict playbook to protect yourself. Your very first move is always about creating a paper trail. A verbal phone call is practically worthless in a courtroom because it's just your word against theirs. You need a tenant notice. That's a formal written communication to your landlord detailing the exact problem, where it's located, and giving them a specific deadline to fix it. You need to check your local laws to see exactly how much time you must legally give them, but a common standard is 14 days. You write this notice down, you take a photo of it, and you send it through certified mail so the post office makes the landlord sign a card proving they received it. Once that notice is delivered, the clock starts ticking. Let's say the deadline comes and goes, and the landlord still hasn't sent a plumber or a roofer. This is where the law hands you a massive hammer. It's called rent withholding. That simply means you stop paying your monthly rent until the landlord makes the necessary repairs. It sounds incredibly satisfying, but it's incredibly dangerous. In many states, you can't just keep that money. You often have to deposit your rent with the local court system or a designated government housing agency. That tells the judge you aren't just blowing your rent money on beer and video games, but that you're actively holding the cash in good faith until the landlord honors their legal duty. The exact rules on exactly where that money goes vary wildly by state, so you absolutely must look up your local housing laws before you hold back a single penny. If you don't want to mess with withholding rent, your second option is a concept called repair and deduct. That's a legal rule allowing you to hire your own professional contractor to fix the problem, pay the bill yourself, and then subtract that exact cost from your next month's rent. If your rent is $1,000 and the approved plumber charges you $300, you hand the landlord a $700 rent payment and a copy of the paid plumbing invoice. But you've to be extremely careful here. The law usually requires you to give the landlord their proper written notice and their full legal window of time to fix it first. You can't just bypass them and call your buddy on day one. Also, most states cap how much money you can spend on a repair and deduct, frequently limiting it to 1 or 2 months of rent. So you can't remodel the whole kitchen on the landlord's dime. You need receipts, and you should take photos of the finished work to prove it was done properly. When the situation is completely dire, you've a third option on the table. If the property is so dangerous that it's legally unlivable, like if a tree crashed through the roof and exposed the entire interior to the freezing weather, you can invoke a constructive eviction. That's a legal term for breaking a lease without penalty because the landlord's neglect essentially forced you to move out. The property became entirely uninhabitable, so the law treats it as if the landlord kicked you out themselves. If you follow the correct legal steps, you can pack your bags, hand over the keys, and walk away from the lease without owing another dime of rent. But constructive eviction is a very high legal bar. You generally have to prove that you gave the landlord written notice and a reasonable amount of time to act, and that their total failure forced you to leave. You usually can't claim constructive eviction over a leaky faucet or a noisy neighbor. You must be able to show a judge that any reasonable person would have moved out to protect their own safety. There's one more power you hold as a tenant. You also have the right to sue your landlord in local court for breach of contract. If you had to live without heat for a month because they ignored your certified letters, a judge can order the landlord to pay you financial compensation for the days you suffered through it. You can ask the court to force them to pay for a hotel room if you had to leave the apartment, or to refund a large chunk of the rent you already paid for the days the property was legally unlivable. Taking your landlord to court is a slow process, but it's a powerful tool to hit them in the wallet and make them pay for ignoring your safety. Before you start withholding cash or calling contractors, you need to understand how easily a landlord can strike back. If you miss one step or mess up your timeline, the landlord will likely slap you with an eviction notice for non-payment of rent. They'll claim you're just a deadbeat tenant trying to get out of paying your bills. You've to walk into a courtroom ready. That means having photos of the black mold, copies of the certified mail receipts, invoices from licensed professionals, and a clear paper trail showing exactly how many days the landlord ignored the problem. You should also check if you live in a jurisdiction that has something called a retaliatory eviction law. That's a legal shield preventing a landlord from evicting you simply because you exercised your legal rights, like reporting them to a city housing inspector. A landlord isn't allowed to punish you for demanding basic human safety, but you still have to be able to prove that's why they're trying to kick you out. If your landlord ignores a busted pipe, you've real power to force their hand, but the system demands total precision. If you miss a step or act out of pure anger, you'll lose your leverage and end up evicted. You must document everything, follow your local deadlines to the letter, and keep your money ready to prove you're acting in good faith. Dealing with a slumlord is incredibly stressful, especially when your health and comfort are on the line. The law is on your side, but the law only protects the people who follow its rules exactly. What is the worst repair your landlord has ever flat out refused to fix for you? Let me know down in the comments. If this breakdown gave you a roadmap for holding your landlord's feet to the fire, please share the video with a buddy who is currently stressing over a busted boiler. And make sure you subscribe to Scribble Law so you always know the exact playbook before someone tries to use the legal system against you.